Hi, y'all, and welcome to tonight's live stream. Well, I've been in the courtroom all week for the murder trial of Brooks Houck. He's been accused of murdering Crystal Rogers, his girlfriend, and the mother of his child. And I have to say that of the 8 days that I've been here, this was just weird, totally upside down. We'll get into that. Crystal Rogers disappeared 10 years ago today. Brooks says that he woke up on the 4th of July and she was just mysteriously missing from their bed. She has never been seen or heard from again. Her car was found along the Blue Ridge Parkway, and inside it was her wallet, her cell phone, and that's the last that anyone has seen of her. Now, today, Brooks Houck wrapped up his defense case with 2 expert witnesses. And bizarrely, one of them said that the police did a terrible job. They went way too far. They coerced witnesses. And the other witness said that the police did a great job, really exemplary, as they searched for evidence. So what is going on? Brooks Houck's co-defendant, who is charged with tampering with evidence and conspiring with Brooks Houck to murder Crystal Rogers, rested without putting on a single witness or a shred of evidence. It's his right, but was it a good idea? The prosecution put on a 10-minute witness then in rebuttal, and bam, we are done with the evidence part of the trial. Now the trial evidence is all in, and we're headed into closing arguments. Those will be Monday. And they're going to be pretty long. The jury will begin deliberating on Tuesday after the closing arguments end. So let's talk about this very strange day and how it might shape what the jury decides next week. The first 5 in the chat tonight: Betsy, Neuropsych, Zena, Angel LaFawn, KS, and Connie. Special shout out to you and to everybody on tonight. All right, so let's talk about the 2 witnesses. And there were only 3 witnesses today. 2 for Brooks Houck, and then 1 for the prosecution in rebuttal. So the first witness, Jeff Neuschatz, was for the defense. And what he was saying is that those interrogations that I told you about last week were in fact very coercive, badly so. And he talked about that. Neuschatz is a professor and a cognitive psychologist. He was a little outside kind of his specialty, which is about memory. He's done a lot of work with eyewitness memory. He's done research in confessions. This was a little bit further along because he was really focused and specialized on the coercion techniques. They went for quite some time, maybe even 45 minutes, about various studies that he knew about and sort of general things like the idea that media coverage can change your memory, or what is locked into your mind as your memory. And that post-event information, in other words, stuff you find out later, can change and contaminate your memory. And it was all very interesting. I did think it was a little bit long because none of that was the point. All of that was just kind of, well, this is fun and this is interesting. But here is what the point of what he was there for was, and that's the idea. He talked about something called the Reed technique. It's a way of interrogating witnesses. It's a specific method. And one of the 2 detectives who was in charge of the interrogations of the 2 witnesses who were most who were coerced, according to the defense, that these 2 witnesses were interrogated by a detective who had just been trained the year before in the Reed technique. He said it's criticized, but it is still used by law enforcement. And he said that even though it's criticized, it has some rules within it. And if those rules are violated, then even the Reed technique would have to admit that it was a coercive interrogation. And he said that's what happened here. Even the Reed technique creators would believe that this was an inappropriate coercive interrogation. So the Reed technique teaches that you do not get a false confession unless you do a few forbidden things during your interrogation, like make threats to the witness or interrogate them too long so they no longer have control of their faculties thinking wise, or if you feed them information that can contaminate what they recall, or if you make them promises, and then there were three, I wasn't sure if he was saying these were incorrect under the Reed technique or if he just thought they were, but one would be minimizations. That's where you tell the witness, yeah, that's not right, or that's not the whole story. And maybe they were telling you their full entire memory. Then also social and psychological pressure related to, say, a family or people in that person's life or how those people perceive them. And then finally, touching, even to show sympathy, and not just beating someone, but to show sympathy and that you're on their side. So the two witnesses, and he went through their interviews, were Charlie Girdley and Heather Snellen, the hands down most important witnesses of the trial, I would have to say, because of the bombshell information that came out of those interrogations. The defense wants to say, may have been bombshell, but you know what? It wasn't accurate. It was contaminated, false information because these people were interrogated coercively. In other words, they forced it out of them. They created these memories or convinced them to say these things when even they didn't really believe it at the time. So we covered some of that. I want to go through focusing on the interviews. We actually got to see them this time. There was a tiny clip last time, but we got to see more of the interviews, not the whole thing, just little clips, which I thought was very effectively done. In the Girdley interview, the witness counted up how many times the Reed technique and those 7 factors I gave you, how many times those were violated, and it was 314 times. For Heather Snellen, and he was interrogated over 10 hours, so that was obviously a lengthy time. The time, he says, starts when you bring them in until you interrogate them, not just during the time when you're actually asking focused questions. For Heather Snellen, she was interrogated for about 4.5 hours, for something like that. And 350 times they used these coercive techniques on her. They promised her leniency, made threats, told her they might take her child, things like that. These interviews, he said, in his opinion, were not just coercive, he said, quote, very coercive. So starting with Girdley, one of the things that they did, they touched him 50 times during the course of the interview, not in a hitting him, trying to hurt him way, but in a reaching over and connecting with him way. He thought that was inappropriate, the witness did. So we then got into the clips of what had gone on in these interviews. I do think this is really, really important. They said things like, and he went through it and played these parts. We can do a lot to help you. And then, so what he would do is he would play a clip, we would hear what was said, and that's kind of how I'll present it to you. And then he would say, okay, what is the breach with this? So we can do a lot to help you. Well, that's a promise of leniency. So making promises. They said, usually you don't have a prosecutor on hand appointed by the Attorney General. And tonight we do. We have a prosecutor on hand who can make a deal with you. The two things that violated were that it emphasized the seriousness of this. We've got a prosecutor waiting. This is so important. And when you have a serious event, then that could increase the potential consequences. So it becomes then coercive, a threat. The detective told Girdley, when I bring someone in this room, I already know what I'm looking for. That's, in other words, a statement that if your story deviates from what I think, then I'm going to reject that. And they told him, you're not the one we're after. He said, that's minimization, where you're saying, yeah, don't worry. Minimization is where they tell the person that, they say, you know what? Everybody drinks a little too much. That happens to everybody. But the issue is that the person drank too much and then went through a stop sign and killed 10 people. And so just saying everybody drinks too much minimizes the consequences potentially to the person who's being interrogated. They made statements like, we want you on our team. We can help you today. We can help you with the other stuff you got going on, because he was picked up on a warrant for the state or for another matter. And then he was brought to the investigators in this case. And they said that's a promise of leniency, Neuschatz said. And they told him the opportunities are going away. I guess I would call it the deal of a lifetime, which again emphasized how serious this was and made a promise of leniency. So his first statement to them, what happened? He said, well, I was at this pre-4th of July party. We have a party on the 3rd every year. I was riding with my daughter, and it had no incriminating information in it at all. And they would not accept that. And they told him, we have several people talking about your involvement, which was emphasizing this evidence they supposedly had, and that they would reject any story that didn't match with what they had told. And again, what I'm doing as I explain this is I'm telling you what was asked and then how the witness explained how it was a violation of the Reed technique. So there was information degradation, meaning saying that first story you gave us, that's wrong. We don't accept that. And there was a promise of leniency that they would help him out. We'll help you out if you just will do this. So, and there was in the course of all this, putting the hand on the knee. So Girdley said, well, what's my involvement? What do you mean by my involvement? And Detective Leckett said, rather than answer, said, did Brooks Houck speak to you about picking up a car at all? And the answer was, no, sir. So law enforcement brings up a fact, Brooks Houck and picking up a car. Those are things he hasn't mentioned yet. So potentially contaminating his memory about what happened. Then they tell him these are the best I can do on my quotes. I'm writing furiously, so I don't know for sure that I get it all correct. But this is close. I promise you, this is a once in a lifetime opportunity. Sometimes the Lord smiles on us. This is a once in a lifetime opportunity, and it's a promise of leniency, the witness said. We will make sure we protect and take care of you. And they bring up his family and say, we'll take care of your family, almost suggesting that maybe they would get dragged in if he wouldn't say the right thing. That is a manipulation, the witness said. About an hour or so in, he changed the story that he was saying. And he said, Brooks Houck asked me to pick up a car on the Bluegrass Parkway. Well, they didn't accept that story. And law enforcement gave him a big hint then by telling him, basically, it needs to be the Lawsons. They told him, we've had another individual in custody. I won't say who, 2 individuals, their last name is Lawson. So now he has the information that probably the Lawsons need to have something to do with it. And they told him, today is your one and only opportunity to get ahead of this. This is a pivotal moment in your life. Telling him, in other words, it's in his self-interest to say what they want to hear. They told him, you don't want to be on the wrong side of this. The gavel is coming down hard. And he said, I believe that. And it's like, I believe that. Yes, I think that is happening. And at one point, they went into belligerence, banging on the table, and what the witness called belligerence. And they said, this is a pivotal moment in your life where you decide whether you spend the rest of your life in a penitentiary or can walk out of here. putting it to him like, that's your choice. That's where you are in this. So a little bit further into the interview, he says, Joey Lawson and Steve Lawson. Now, Joey Lawson is Brooks Houck's co-defendant. Steve Lawson has already been convicted. The jury recommended 17 years for his sentence, but he hasn't been sentenced yet. So he says Joey Lawson and Steve Lawson did move the car. Where to? I don't know. And they said, yeah, okay, well, how did Joey Lawson get the keys from Brooks Houck? And he said, at one point he said, I'm trying to remember correctly, which I thought was really a really telling kind of comment. Not just I'm trying to remember, but I'm trying to remember correctly the way you want me to remember is how it sounded to me. There was a long period where he thought about this and tried to figure it out. And he said, they said, in the middle of this, they say, any family members of yours are taken care of. And he said, I believe Brooks Houck brought the keys over to Joey Lawson. And they say, well, somebody else might have been there. Remember exactly who that person was. And he says, okay, we were at Kenny's house and there was this young blonde-headed boy with Kenny. And Brooks Houck came into the living room and made a few jokes, like cut up with us a little bit, and then pitched the keys to Joey Lawson. And then he left. So that story, I guess it would be story number 3. They were like, no, your story's not right. Again, information degradation, the witness explained. And they, at this point, and I may not have this totally correct, but at this point, the prosecutor comes in and says, and literally the prosecutor sitting there in front of us who is prosecuting this case, says, I'm going to help you. I don't get out of bed for just anything, for just anybody. And says, I'm extending my hand to you. Take it, grab it. I'm going to be able to pull you up out of this. I'm going to help you. And the expert witness said, yeah, that's a quid pro quo. That's a promise of leniency. You give me this, I give you that. And also emphasizes the seriousness of the case. The idea that this prosecutor is here because this is really important. And when a case is really important, the consequences are high. So it also, thank you, Chop Trials. Love the new pillow. Well, thank you, Chop Trials. I appreciate that. All right. So the detective, at this point, the detective, quid pro quo, lenience. The detective says, when I tell you I got you, that means I'll help you. And I don't give an S word if you are the one that killed her, which is minimization, the witness said. And then the prosecutor, I do think that the prosecutor appearing in the video is a problem. We'll talk about at the end. I want to go into a little bit about my impressions about how this might play out at the end. But the prosecutor literally being in the video that they're playing and that the witness is critiquing is an extremely awkward situation at absolute best. So Girdley comes up with yet another story. I believe this would be story number 4, because first story was nothing. Had nothing to do with this, don't know anything. And this one was that he met Brooks Houck at 10:30 p.m. at Copperfield, and that was not accepted. And they said, think where Charlie Girdley is in life and think about what Detective Luckett and I need from you to allow you to be on our team. Again, the expert witness said, appealing to his self-interest. So he then says he asked Joey Lawson to give him a ride to Brooks Houck to get paid. And that's how he got paid. And that was not accepted either. And the prosecutor, and I could not tell if it was one of the detectives or the prosecutor. They were you could kind of see a hat. And that's all you could really tell. Said the Times said, but I did think it was the prosecutor, but I couldn't tell. And he said, that time is right. This is how the expert witness described it. That time is right, 7 to 7:30. 8 o'clock was right, but I'm trying to figure out where. In other words, I don't accept your statement that it happened when he took you over to Brooks Hout's house. I don't accept that. And suggesting I'll agree with part of that, but not with part of it. Then they said to him, did Steve Lawson come to tell you that Brooks Houck needed to get rid of Crystal Rogers and ask you if you could do it, and you laughed it off? And that's the story he agreed to. Now, the way I heard it anyway, and I did have a hearing assistance thing. You can get these. It was, anyway, it was like they have a few for the courtroom, which are quickly stacked up because it's hard to hear. But I managed to get one today, thanks to Allie. Appreciated that. And so my hearing was that they asked him this, and then that was the story he adopted. In other words, it wasn't even a story he came up with himself. So now let's move into the Heather Snellen interview. That's the one where I told y'all that it was the most incredible cross-examination that I have ever witnessed. It was crazy, where the witness and the defense attorney who was cross-examining her, who should have been opposed to her, they were basically moving in lockstep, talking about how upset they were about what had happened in this interrogation. So we actually got to see parts of it. And she ultimately would say that she overheard a conversation between her boyfriend at the time, Steve Lawson, and Joey Lawson, in which they were talking about moving a body at the Houck farm. So we saw a clip where she's told, your life's going pretty good. I want to keep it that way. And she's crying and saying, I want to keep it that way too. And they tell her, I'm the best friend you have now, the detective says. And the witness said, no, he's not. That misrepresents his role. They said, you need to decide whether it will be, I'm getting out of here, going to have a life with my little boy or not. And she is crying. And the witness says, Newshat says, that's really pushing her towards self-interest as opposed to the truth. And that's how you get false statements. And that they told her it's the most high-profile case in Kentucky, which emphasized the seriousness and how much trouble she could be in the context of this case. They told her, I'm going to take a break. You think about it. Think about whether, what you want to do. Do you want to raise your little boy who's cute as a button? And are you ready to end this interview and get out? And she's crying and she's like, well, I want to say yes and kind of no. She's like, I want to say yes because I want to end this, but no, because I don't know anything more to tell you. And the detective said, that phrase right there, that's how we determine when someone is lying to us. And they say, whenever you come off, where do you want to be? And she says, with my son. And again, they're refusing to accept any of the statements that she's giving them. The witness says that's information degradation, where they're refusing to accept information she's giving them. And they're conditioning everything, like seeing her son, on her saying exactly what they want to hear. At one point, he yells and hits the table, and she is crying. And he says, that's belligerence right there. That's a technique, but it's inappropriate. They accuse her of lying and say, if you want to be back with your son, you'll tell the truth. She's told, we all make mistakes in life. No matter what you think you're culpable of, we want to protect you. Again, making kind of a promise, but that's not really a promise. We want to protect you means, well, we would have liked to, but it turns out you did something terrible and you confessed to it. So there's nothing believable in that. And they say, I don't want to see you hurt. I don't want to see you in jail. You're a good mother, that kind of thing. And your son depends on you to hug him. Did you hear the way he was talking to you on the phone? They ask her, we got you, Heather. You're still holding back. Please, I beg you, don't hold back. Bring it all the way home, Heather. He depends on you. Don't hold anything back. And you are, I can tell it. Don't do that to him. Enough little boys are without their mothers. And she is just crying, and it was brutal watching it a second time. So she comes up with a new statement at partway into this saying, okay, Joey Lawson and Steve Lawson, I heard them say they killed Crystal Rogers. And they reject that. They're like, yeah, no, that didn't happen. And then they say that her idea that she's going to go home and have dinner with her son, that dinner will be irrelevant if you don't tell the truth. And a threat, the witness, Newshat said, if you don't tell us what we want to hear, you don't see your child. She's standing up. She says, I'm leaving. And they block her from going and say, I don't want to take you from your little boy. And the witness says, this is really inappropriate. This is a non-custodial interview. She's not being arrested. She hasn't been charged with anything and isn't being charged with anything. And yet she's not being allowed to leave. He says he's worked over 100 cases, and these are some of the most coercive interrogation tactics I've seen in my career. So the cross-examination was very effective, I thought. It was well done. The style of the prosecutor is very conversational and very casual. And he says, now, Girdley at the time of arrest, we found out later, had been doing meth and hadn't slept for 5 days. And that could affect memory, right? And he says, well, yeah, it could. And he says, he points out that coercive interrogation techniques, that's not really this guy's specialty. And that, look, we told her she could leave and she chose not to. But I will say it was kind of like the way it was phrased was, if, look, we're trying to work with you. We're trying to help you out here. But if you want to leave right now, if you want to walk through that door, that's it. We end it. We will no longer make any attempts to help you. She was, let's see. The prosecutor made a few comments today that I think got under the judge's skin because I'll tell you, there were several. Here was one where the prosecutor said, and she, did you know, to this witness, did you know that Heather Snellen went into the police, or she called him and said that Joseph Lawson had written her and asked her if she would be his alibi. She said Joseph Lawson wanted an alibi, and there was a sidebar. And he came back. That isn't really the way I remember the testimony, is that Joey Lawson said, I'm trying to figure out what I was doing on the 3rd. Do you have anything that we were doing? Any note, anything? Do you know anything about the 3rd? Can you remember anything? And that's a little bit different. So we came back, changed the question a little bit. But he had one technique I thought was really good, which is he said to the witness, he said, now, right up here in court, the witness, Heather Snellen, and also the other witness, I asked them to repeat their statements. And I said, look, I just want to know the truth. I'm not putting any pressure on you. There will be no consequence if you change what you said. I just want to know, is what you just said the truth? And they said yes. And he asked Newshat, well, is there anything coercive about that? I mean, they're in court and they're protected, and I promised them they're not going to have any consequences. And he said, no, that's not a coercive technique. And it yielded the same answer. That was the point of the prosecutor. Of course, in fact, once they've said that to the police and then committed to that more than once, probably in documentation, at that point, it is very difficult to change that. It could create real problems. They've already told the court this, they told the grand jury that, and now they change it. Could create a real problem. So I want to make sure I cover everything for you. Oh, here's one. Another prosecutor says, now, if the police are provided information, for example, he was trying to say, if the police are provided information that would make them think this person was involved, maybe they're going to ask questions a little more intensely, and maybe that's reasonable. So he said, if police are providing information, for example, here the police have been provided information that Snellen had been with Lawson at a bar that night. Well, nobody has testified to that. And so that was the prosecutor testifying. So there's a sidebar called, and the prosecutor comes back. All right, well, it's fair to say you don't know what the police were told. And basically she says yes. And he made this comment. It can be like pulling teeth to get someone to tell the truth, which I think was very much at wanting to put in the jury's minds again what Charlie Girdley said, which is Joey Lawson said he planned to pull Crystal Rogers' teeth and feed her to the hogs. So these techniques produce statements that were allowed in evidence, meaning the judge allowed them, so they weren't found to be coercive to the extent they weren't allowed to make these statements in court. All right, let's see. Give me just a second. And then I thought this was also a very effective technique. He's like, yeah, the prosecution just leaned in and said, yeah, once I learned Charlie had been up 5 days while interviewing, I mean, I had to figure that interview was pretty iffy too. That had been learned in the courtroom, so it wasn't like he had known that before. The cross-examination just said, look, we're not talking about whether this is illegal. Nobody's going to arrest the detectives or anything like that. We're just talking about whether this is the truth. And all of this is problematic if what you want is for the witness to tell you the truth. We had a juror question, which I thought leaned a little pro-defense. You tell me what you think. According to your expertise, if an individual goes in voluntarily and they're there for over 4 hours, could their judgment or memory possibly be clouded? And the witness answered, well, yes, that could happen. If they had no idea that they were going to be interrogated and they're there for 4 hours, then yeah, maybe they're a little confused about what they say. So I don't know if that's pro-defense, pro-prosecution. You could read it either way. But it certainly does seem like they at least were accepting that there could have been some coercion involved. There could be some problems with the interview. They may have been considering that as a way to explain or excuse the inconsistencies in her testimony, but it also could have been that they were saying, yeah, maybe this was all invented. Who knows? We will find out when the jury makes a decision, won't we? So I want to talk for just a minute in general about what all of this coercion means. I think the biggest issue with this is that it causes a lot of question around the really bombshell information that both of these witnesses had about statements they heard Joey Lawson say. Both of them were connected to Joey, not to Brooks, but the statements related to both of them. And I think the fact that they were so coercive, I think is really going to affect the way the jury thinks about the case, at least about those witnesses. I don't think it will change everything. But for those witnesses, I think it will depend on the jury makeup. And for some jurors, the idea that the police were intentionally coercing testimony and trying to push witnesses, that will resonate. That will be a serious problem. And that will cause them to not just discredit the testimony of that witness, but the prosecution generally. For a lot of other witnesses, for a lot of other jurors, I think that they'll be more likely to think, you know, that's the way the police do. It's not like people come in and admit they have all this information. They have to like do some trickery and they have to do some stuff to try to get the truth from people. I think this, if it comes down to it, if this could be a very central issue and it could be a divisive issue with the jury, depending on how important they think this coercion is and what the police did. So let's talk about the other big witness of the day. The third witness was very short. Denver Butler. He was, I just wrote, wow, impressive at the end of his credentials. He was a police officer and he was retired from homicide. He was sergeant over homicide cold cases, worked in Louisville Metro. He was then a state House rep for 2 terms in Kentucky, serving on various justice committees. And in 2020, started a nonprofit to review convictions where there was a claim of innocence. And he works with 2 prosecutors' office trying to look at that. So he was recognized as an expert in police investigations. And he proceeded to do something that is the opposite of what is normally done in a case. Normally in a case like this, you have people looking at the defendant is busy looking at the police investigation and saying, look, that was a really flawed investigation. You didn't look here. You didn't look there. You missed this. You missed that. And if you had only looked at all of those places, you would have found evidence that would exonerate me. You would know I was innocent. And the fact that you didn't look, I'm allowed constitutionally under the Supreme Court's ruling, I'm allowed to put that in front of the jury that it wasn't a sound investigation. But here, turn that on its head. It's the opposite. They went to great pains to say kind of the opposite of what we just heard from the other witness, which was very coercive techniques, improper police work, to say the police went over and above board. They worked over and over to try to turn over every stone to find Crystal's body, to figure out what happened. They did everything they conceivably could. And I'll just give you a quick rundown. It took a while and they did a bunch of PowerPoint things, but they did a Celebrite extraction from several people, Tammy Lawson, the wife of Steve Lawson included, and where they talked about that 300 Chrysler that got stolen. If you want to know more about that, we won't go into the details. We've gone over it a couple of days in a row. And they had Crystal Rogers and Brooks Houck talking to each other. They added a little bit about a conversation between them just the week before Crystal disappeared about Eli's eye appointment. They're once again trying to suggest those tinted windows in Brooks' car were only there because he was trying to help Eli. Eli had a congenital eye condition and he needed protection. He couldn't have exposure to bright sunlight. So, and then they responded to the crime scene where they swabbed various things around the car, did trace lists, looked for fingerprints, DNA, nothing, absolutely nothing came back hitting on Steve Lawson, Joey Lawson, Brooks Houck, anybody. They found one hair, but it was not tested. One hair, may I say, that was not similar to Crystal's, but they didn't test it. And they found one hair on the driver's seat, one on the floor, one on the driver's seat. And those could have been tested, but they were not. Then they did a search of Brooks Houck's home by consent and found nothing. They searched his truck, also by consent, and found nothing. They searched the police cruiser of Nicholas Houck, Nick Houck, the brother of Brooks, and found nothing. They searched the car of Anna Whiteside's, Brooks Houck's grandmother, and found nothing. They did, I mean, this is actually amazing, multiple searches of the Houck farm. Here are the dates I got. July 6th and 7th and 10th of 2015. And then in 2016, the 30th and 31st of August, and then in, I see what I wrote. Okay, August 6th through 9th of 2020, and then October 17th through 20th of 2022. So multiple searches out there. They did not find any evidence that a crime had been committed. They did not find any trace evidence associated with Crystal Rogers. They didn't find any of Crystal's personal effects on the Houck farm. They searched, as I said, the white Buick. They found nothing, no human blood. They found the hair, one hair similar in color and length to Crystal's. The characteristics were the same. They tried to get a DNA profile. They weren't able to, and the hair was consumed, so it's gone. They did a search at Anna Whiteside's home at 3505 Cox's Creek and even got the vacuum and rags and found nothing. They searched at 730 Pulliam, vacuums, rad, shop vac, vacuum, nothing. They searched Fabian Ballard's farm near the Houck farm. They swabbed a front end loader and a shovel, nothing. Did luminol testing, searched multiple bodies of water, including Melody Lake, Sportsman's Lake, and Fagan Branch Reservoir. They did a dive team. They brought in a sonar team from Miami. Nothing. They did a search of when they searched the Houck farm, those multiple times I told you about, they used canines and drones and ground penetrating radar. They had over 100 agents. They searched the home and the outbuildings, including the skid house. They searched the pond and they conducted grid searches. I mean, I have to say they were really impressive. In most of the cases, we're talking about things that didn't happen and where they didn't look here and didn't look there. And wow, they went all out. They did a search at North Howard. They had where the FBI dug up the driveway and the porch. That property had been being developed about the time that Crystal Rogers disappeared. They found a pair of women's underwear with hairs on it and clothing under the sidewalk. And they thought maybe this could be Crystal Rogers, but her DNA was not found on these items. Later, they clarified a little. Apparently, it's not just they tested it, it was consumed, and they were not able to get any kind of sufficient data. It wasn't that she was excluded, like she wasn't there. They just didn't find any, they weren't able to get any results that they could use. Thank you, Dolly. I appreciate your super chat and that you've been a member for 10 months. And Dolly is concerned about the interview techniques. I am too. It bothers me a lot. KS, thank you. I'm glad you loved the lunch live. Today, we did Kohberger. I wanted to talk a little bit about Kohberger and the death penalty. If you haven't watched that video yet, when we finish up here, I would love it if you would go watch that. I talk a little bit about my experience as a young lawyer when I worked for a court that did a lot of death penalty work. And I talk about why it is I believe the prosecutors made a deal with Kohberger. So thank you, KS. I appreciate the feedback and the encouragement. And Marlon, thank you. Can you explain to us at the end about the 11th Circuit? Yes, I can. And help. I'll leave that up so I can remember. Thank you, Marlon. Okay, so the Houck farm search included the gazebo behind Rosemary Houck's home. They looked under it. They dug near the house and the garage, and they found nothing. Thompson Ridge Farm, that was the last search. In 2023, they were looking for remains, for bones, for teeth. And it was 3 months, and they pointed out it was 3 months after Brooks Houck was indicted. So they'd already planned to move forward without a body. And again, they found absolutely nothing of value. The witness drove from Thompson Hill Road to Glenview, which is Thompson Hill is one of the places they searched and where Steve Lawson went during the evening. Glenview is where Brooks Houck lived. And then there's the Bluegrass Parkway where the car was found of Crystal Rogers. And they drove that. And I thought the prosecution made a good point. It's like, why did you do that driving? What was the point of that? And he said, well, counsel wanted me to. Yeah, but why? Because no one is suggesting that Brooks Houck drove to mile marker 14 where Crystal Rogers' car was found. And no one is suggesting that he drove to Thompson Hill Road, where we did do a search, hoping we would be able to find some evidence. There was evidence. We had a witness come in and say that there was a dig in the wee hours of the morning/night of July 3rd, really the wee hours of July 4th, just after the 3rd. And someone was out there digging and dumping something. So could that have been related to Crystal Rogers? Who knows? They also searched Cox's Creek, looking under that's Anna Whiteside's home, looking under the porch, in a well, the basement. They tried all of that. And they found absolutely nothing. Now, in the cross-examination, the prosecutor asked the witness something about a little boy who was murdered and they never found his body. And the witness said, yeah, I think they did. I think it was in the back of a garbage truck or something. And the prosecutor was like, nope, they never found it. And then, so on redirect, the defense lawyer gets up and says, okay, here's an article. Isn't it true they found the little boy? I think what the prosecutor is trying to say is it is possible for a body to just disappear. This sometimes happens. So it's not something that is completely out of the realm of possibility. Let's see. Joseph Lawson, I think you know all that. I don't think we need to go into that. The prosecutor tried to get him to undermine the other witness by saying, well, you get people to write statements, don't you? Because the first witness had said, yeah, you don't get people to write statements. That's not the right thing to do. And he said, no, I never did that. So it didn't work at all. All right. He also said, I watched the full tape of interviews that I thought were coercive. So he supported what the first witness had said. And then here's this question from the prosecutor. I told you, I think he was getting under the judge's skin a little bit. He said, if you had to plan a murder, objection, sidebar, and he comes back. And I mean, obviously he's not going to be allowed to ask the witness if he had to plan a murder, what would he do? So, but it was entertaining. He's a really good lawyer. All right. So juror questions were huge here. But there was one point, was it with the next witness? Where they actually, oh yeah, that's the next witness. Okay. Juror questions. Because those are so important. I think they really give you a little window into what the jury's thinking. And the first one says, was December of 2024 the first time that Thompson Hill was searched? Answer, yes. Was Joey Lawson's or was Steve Lawson's vehicle searched? And he said, not that I'm aware of. And then the juror asked, well, how is blood or trace evidence affected by rain? And he said, well, it could dissipate it, but it's not really going to get rid of DNA. That's still going to be present. And then said, well, how can it be affected by snow? And he said, well, the same. I mean, DNA will dissipate, but it's probably still going to be there. And then he was asked, well, what about fire? And he said, well, there are cases where you find teeth or other items that are in ashes from a fire. So how, and I assume they were thinking about that area where there was a burn. The night Crystal disappeared, as well as the next day right there on the Brooks-Houck farm. And the jurors also asked, well, okay, how could blood or trace evidence be affected by time? And he said, well, DNA is the most powerful, and it would be reasonable to expect that to still be there after 10 years. So at this point on recross, the prosecutor gets up again. And this is the part at which he said, now he said, well, isn't it true that cases hardly ever have DNA? That's more or less what he wanted to say, that's like not very often. And the witness is like, no, there's always some kind of DNA in a fresh case. That might be the case in an old one, but nowadays there's always DNA. And the prosecutor says, I've been doing this 25 years and only had 3 cases with DNA. And there was an objection. And normally the judge has everybody go up to the sidebar. The judge sustained it right in front of the jury. Now, I don't think they had any idea what that meant. I just noticed it. Sustained. And they didn't even go up to the bench. She's just like, no, you can't. Because what the prosecutor was doing was testifying. He was saying, well, vouching, in fact, saying, I've been a prosecutor for 25 years and I've only had 3 cases with DNA, and introducing a fact for the jury to consider. So both defendants rested. Joey Lawson, no witnesses, no evidence, just accepted what Brooks-Houck had done. And that's pretty much been the way the whole trial has been. We have rarely heard from Joey. Then we had one prosecution rebuttal witness. And I wasn't completely sure about why we even had that one. He's the chief of police of Jeffersontown, a suburb of Louisville. And he's he was at one time the state police commissioner, obviously very distinguished. Spent 6 years in Miami on a Miami Vice kind of job and ran the Chicago field division of something. So all the prosecutor asked him was, have you taken the Reed School of Interrogation? And he said no. And do you use the Reed techniques? And he said no. So I'm not really exactly sure where that, because I also got that the defense didn't believe that the Reed technique was appropriate either. So in general, maybe no one believes it except the one detective who took the course the year before he did the interrogations. So there was no cross. There was a quick, the jury was dismissed for the day, and we had a very quick argument from Joey Lawson's, well, both. The Houck's lawyer just stood up and said, I renew my motion for a directed verdict. And the judge said no. It was just very quick. And Joey Lawson stood up and said, well, I want to present a new case because I want to point out that my guy, Joey Lawson, is accused of concealing, altering, or destroying physical evidence. That's what tampering with the evidence is defined as. And he says, well, here, the car was right there on the Blue Ridge Parkway, so it wasn't destroyed and it wasn't concealed. Anybody and everybody could see it. And it wasn't altered. There's no evidence that he altered it in any way. It had DNA and hairs and stuff in it, so nothing had been altered. And the judge is like, yeah, no, we're taking this to the jury. And we talked about what will happen on Monday. The defense lawyer for Joey Lawson said he thought 30 minutes to an hour for his side, his presentation for closing argument. The attorney for Brooks Houck said it would be about 2 hours for him. And then there will be lunch and the Commonwealth will go. So in the morning, the defense argument, lunch, and then followed by the prosecution. And he said, we will send the jury home and draw it out on Tuesday a.m. I've never heard that expression before, but I thought that was really interesting. I believe what he meant was we'll allow them to begin their deliberations in the morning on Tuesday. So if you have questions, if you would put your question marks at the beginning, that will help me spot them in the chat. And I want to start with Marlon's question about, can you explain about the 11th Circuit? Today, when I did the video about Koberger and the death penalty, I talked about having clerked on the 11th Circuit. So the way the U.S. federal court system works, you have district courts, which are the trial courts. I clerk for an appellate court that hears cases from the district court. So we would be doing the appeals. And the entire country is divided into regions. And a certain number of states will go with this circuit and a certain number with the other. So there's a First Circuit, Second Circuit, Third Circuit, etc. I clerked on the 11th Circuit, which covers Georgia, Alabama, and Florida. And as part of our work, we would deal with any kind of appeal that came from a trial court in Georgia, Alabama, or Florida on the federal side. Now, this wasn't state court. This was federal court. With a death penalty appeal, though, they go through the state court and through the federal court. There's no, it isn't like it's only on the state side like other cases are. The death penalty cases run through the federal courts as well. So we were hearing cases that came out of those three states as appeals. The court that I clerk for, the appeal from that is directly to the U.S. Supreme Court. These are there are 11 circuits and a D.C. circuit, and those are directly below the Supreme Court. And so if someone doesn't like what the 11th Circuit decides, then they can try to appeal to the Supreme Court, which rarely takes cases. Now, in a death penalty case, there's going to at least be a rejection or sustaining of whatever their request has been. There's going to be some kind of there's going to be something coming out of the Supreme Court. They're not going to just say no and reject it entirely. So that is where I clerked, was on the 11th Circuit. All right, so let me go back and see where we started with the questions. Okay. All right. Why does Lee do the first 5 in the chat? Just for fun. Just say thank you to people for coming and chatting and for being here. I appreciate it. All right. So Chris Hurst says, it seems as though whoever was involved of the suspects, they sure did a lot of in-your-face situations to throw off and take the time of investigators. I think a lot of planning took place. I don't think that's really as much of a question as a comment, but I appreciate your comment. I think Chris is saying that it seems to him that people were throwing off the police. I will say on those 2 interviews, it could be that they weren't telling the truth because what they were trying to do was avoid admitting something that they knew, but they were really coercive interviews. I do think it's really important that those interviews be made public in the state of Kentucky, because I think they're just things that people need to talk about and think about and consider. I think it's important, and the public needs to be aware and be thinking of things like that. Do we approve of that? And if not, what do we think the rules ought to be around police interrogations? Ask Mickey's Mouse wants to know, will the jury instructions be created strictly from the judge, or will the attorneys have input? It's both. The way in some courts, the attorneys turn in proposed jury instructions, and then the judge says, yes, yes, no, no, change it here. In this case, that's pretty much the procedure that's going to happen. He's asked for them to get their proposal to him by Saturday evening, early Sunday. He said at 7 a.m. Sunday, he's going to start working on it and work on it all day. So he has a lot of input into it, and he'll probably have some standard instructions. He always does. So he'll have that as well. All right, looking for question marks at the beginning. Here's from Meowsers. Are jury instructions slanted to answer guilty or not guilty? Well, they're not supposed to be. They're supposed to be slanted just straight up, as in, not slanted, I guess would be the way to say it. That just, here is what the law is. Does what happened here fit? Yes or no? And that's how it's supposed to be. So the instructions will be statements about the law and the rules that the jury should apply. And then the jury verdict form is where they fill it out to say guilty, not guilty, for each count that the person is accused of. So hopefully not slanted, not intended to be. And let's see, Christina Marie asked me, I thought they were, right. I wrote that down. This first thing, I wrote, where is the AT&T expert? Yes, Christina. And they were supposed to call an AT&T expert because, and see, that's another speaking objection or speaking incident right there, because in the middle of this cross-examination, the prosecutor said to the witness, well, an AT&T expert is going to come and say that you're wrong and that they can't use this NELOS data that you want to use, that you get from AT&T. The witness is like, okay, well, the AT&T person never came, but the statement about how AT&T doesn't approve it, and AT&T is going to say, we were told, that your claim that they say it's 90% accurate has never been anywhere in their documentation, and they've never said that. But we never got the AT&T witness. So, but again, that kind of fits with what the witness who was first today says, like creating a memory, because maybe the jury will be like, oh, well, remember, we can't trust the NELOS data because AT&T says it's not 90% effective, or whatever his expression was, however the witness had explained it. So who knows? That may be something that ends up on appeal. It's a small issue. I don't picture that being something that would cause the case to be reversed, but. And Christina Marie also asking about the blanket in Nick's patrol car. And I don't remember them mentioning the blanket during the testimony today, but that is something we heard, that they tested the blanket and found nothing. They thoroughly combed through Nick's cruiser and they did not find anything that was important or had any relevance to the case. And as you could kind of hear from that litany of things, that happened for place after place, vehicle after vehicle. They just didn't find anything. And it wasn't because they didn't try. They were trying very, very hard. Thank you, Megan. I appreciate that very much. All right. Yes, I always forget to say this. Would you please like the video and subscribe to the channel? I would appreciate that. Thank you very much for reminding people in the chat over here. I appreciate that. Sunset Gazing has been a member for 8 months. That's awesome. And I would like to echo happy 4th of July to all of you. I hope you all have fun days planned for tomorrow. Have a great time. Connie Brown says the local rumor was that there was a blanket in the trunk of Nick's patrol car and it lit up like a Smurf. We were told that. We were told that today. Okay. You're right. Maybe we did hear about the blanket because we heard about the lighting up like a Smurf, but supposedly nothing was found in his car. Which is it? So I don't remember what it was. I remember the witness calling it lit up like a Smurf. And I remember him specifically using that terminology. So what happens with luminol testing is they put this light on and they get a presumptive positive. That means the light tells them what you're seeing here could be blood. It shines, it looks different, it looks blue. I don't really think it looks blue, but that's what people call it. And so it lights up and you can see this area might be blood. But that's just a maybe. It's not a confirmation. Then if it lights up and you think it might be, then you take it into the lab and they test it and then they can tell for sure. And all of the tests they ran after luminol said it's actually blood. Some other stain. It could be a chemical or just, bleach spilled or some item spilled and it created that stain, but it wasn't blood. All right. Well, so my plan for this weekend, S. Mickey's Mouse asked me, yes, I am headed back home. What I'm going to do, closing arguments will be Monday and then the jury will be out. I'll still be covering the case and reporting on it. We will cover it when the verdict comes back and we will talk about that. I also have a great interview for you that you're really going to enjoy. And I'm going to, I think, release that separately because it was just really good. It's with a guy who is from Bardstown. He's a local reporter and he covered this case from day one. He literally was on the Blue Ridge Parkway when Crystal Rogers' car was found. I mean, he went there because he heard it on the police scanner. So we're going to hear from him. A fascinating guy. I think you'll love that interview. So we will be doing that. I'll probably drop that over the weekend, maybe Monday. And I'll talk on Monday probably about whatever has happened in terms of the closing arguments as far as what we can tell. I won't be here personally, but I can pretty much tell you because we've now heard all the evidence. So I can kind of tell what direction people will head. So I will look forward. Is there anybody I missed over here? I don't want to miss anyone. Okay, I think I did it. All right. Well, I will see you all. I hope you have a wonderful 4th of July. I'll drop another video with the interview because I think you'll love that. But the next time we'll go live will probably be Monday. So I will see you then.